Hey guys, it's Jacob Blizzard again. I'm a board-certified criminal law and criminal appellate specialist attorney. Today I'm continuing my discussion with you about the 2255 writ or motion to vacate your judgment as a federal prisoner. The federal system is complicated. Unlike most other systems in the states, you don't go in with a set plea. And a lot of times, a lot of state criminal defense attorneys don't have a lot of knowledge of the federal system, and they get involved in something they're not familiar with, and they don't do a great job. And so you can wind up in a real bad situation. So I want to talk to you today about ineffective assistance of counsel within the context of sentencing, especially because most federal cases don't go to trial, just like most state cases don't go to trial. But there are a lot of times where federal cases go through sentencing that is not a set sentence at the time when you plead guilty. You plead guilty, and a to-be-determined sentence will be given to you by the judge. And your attorney will have advised you in advance, this is a range of punishment, you have this many total offense level points, you have this many criminal history points, and that makes you between this and this range of months and this range of months on a guideline scale. But it's just unknown for sure where you're going to come out. The judges in federal district court most of the time follow the guidelines. That's the point of the guidelines. They're there to be followed. But the judges, of course, have discretion to go outside the guidelines. But sentencing can be ineffective when your lawyer fails to recognize and object to valid objections that could have been raised in reference to your sentencing. That could be something like the career offender enhancements being applied to you, or very old criminal cases that were over 10 years or over 15 years for felonies, over 10 years for misdemeanors that were applied against you in your PSR that led to increased points and therefore an increased sentence. Could be that there were wrong drug calculations of the amount of weight or substance that was used, your role in the offense was exaggerated, you weren't given enough mitigation points, or you weren't credited for the work you did with the government and they used the statements you made to the government against you. These are all examples from actual cases that have been overturned where the lawyer failed to recognize a valid objection or failed to assert a reason why the guideline sentence was calculated incorrectly at the time of the sentence. This is, of course, going to be reflected in the pre-sentence investigation report, so you want to get a copy of that before you go through this process. You can get that from trial counsel, but nonetheless, you're going to want to pursue that line of ineffective assistance of counsel in sentencing, because that's where the bulk of cases lie in the federal systems. And so what you can do is you can get that pre-sentence report, and then you can get the United States sentencing guidelines that were in place at the time of your plea bargain. You can literally go into Google, type in United States Sentencing Guidelines, or USSG, and then the year that would have been either the year of your conviction or the year before your conviction. Those are going to be the guidelines that apply. And it'll actually say what guidelines apply in your case. And then you can compare those guidelines with how your pre-sentence report was calculated. And so you're going to want to go through the guidelines, and let's just say it's a drug case. And there's going to be quantity tables, and there's going to be enhancements for different types of things, whether serious bodily injury occurred, different types of distribution, or maintaining a premises for the purpose of distribution. All those kinds of enhancements that could be applied, mitigation points that could be applied depending on the circumstances. And so you're going to want to go through the guideline manual and compare what actually came out in the pre-sentence report with what the guideline manual says. And make sure to go through that and read through the commentary. The commentary often gives a lot of really good, clear explanation about how these particular points are applied. And then if you're feeling really innovative, you can go look in law books in the law library, or you can get online, do research online, look up case law that's related to that particular sentencing guideline and how it may have been applied in your case. So these are some methods where you can get and start understanding what was done in your case and why things went wrong, and you got a sentence far beyond what your lawyer said you were going to get or what you believe you deserved. And so it's a great place to start, and it's the place where the majority of people need to start. If you're in the federal system in prison, then you were sentenced. So there's always the possibility error in your sentencing. Not everyone can have error in trial, but lots of people can have error in sentencing. So a great place to start, and it can shave years off your sentence. You can find good grounds supported by comparing these two things here together.